All right, any objection to the motion to sequester? I presume none, correct?
No, sir.
All witnesses in this case, with the exception of the officer in charge and Mr. Belaloo, have to leave the courtroom immediately, whether to be called today or at the time of trial. You did take the phone out, right, sir? Sir?
Yeah.
Did you take the phone out?
Yeah.
Okay. All right. Any other preliminary matters? Mr. Mohammed?
No, not from the people.
Ms. Diallo?
None, thank you.
Thank you. Call your first witness.
People call Officer Gregory Brewster.
Okay. Officer, stand up, please. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do.
Okay. It's Gregory.
Yes, sir.
Brewster.
Yes, sir.
Okay, Mr. Mohammed, you can proceed.
Thank you. Good afternoon, Officer Brewster. Can you please restate your name to the record?
Lieutenant Brewster, Trenton Police Department.
Okay, Lieutenant Brewster, are you currently employed?
Yes.
Who is your employer?
Trenton Police Department.
And in what capacity are you employed there?
I'm a patrol lieutenant for the police department.
Okay, and were you employed in that capacity as a patrol lieutenant on January 26, 2023?
No, I was a patrol sergeant.
Okay, and on that day, did you work?
Yes.
Okay, and on that day, did you work in full uniform or modified uniform?
Yes, in full uniform.
Okay, on that day, did you operate a scout vehicle or did you work foot patrol?
Scout vehicle.
Okay, was the scout vehicle fully marked or semi-marked?
Fully marked.
Okay, on that day, did you work by yourself or with a partner?
By myself.
Okay, and how many years have you been a police officer?
14.
Okay, on that day of January 26, 2023, did your duties as a police officer take you at or near the location of 1875 West Road?
Yes.
Is that located in the city of Trenton, county of Wayne?
Yes.
What took you to that location?
I was there for an unwanted subject.
Okay, and what is at that location?
It's at a gas station.
Okay, and upon making that location, what did you do, if anything?
I made contact with the clerk who called.
Okay, and what did you learn?
Oh, I'm gonna object this to hearsay.
Any response?
Judge, I didn't ask about any specific statement. I'm just asking the officer what you learned since his investigation.
At least it's overbroad, sustained, rephrase. Is this the gas station on the corner of Fort and West?
Yes, sir. He King's Mobile.
Thank you.
Okay, so sir, you indicated you had contact with the clerk.
Correct.
Okay, why did you have contact with the clerk?
That was the call.
Okay, and
First
after
objection of the
having
day,
contact
hearsay.
with that
It might
clerk,
sound
did it have
technical,
any
but this
effect
is a
on you?
battle over what the jury even gets to
Did it
hear.
cause you to
If the
make
judge
a-
cuts
your
it,
next
that
decision?
piece of the story just
Okay,
disappears.
Your Honor, at this time, I think the statements by the clerk would come in under effect on the listener. The officer indicated.
We'll ask your next question. She can object if she wants.
Okay. Officer, what did you learn from the clerk that caused you to further your investigation?
Wait 1 second.
So Judge, I am gonna object to hearsay. So I think the way we might do this is based on what you learned from the clerk. Did you do something as opposed to her words coming
Sustain,
out?
sustain.
Okay, officer, based off of what you learned from the clerk, did you do something based off of those statements?
Yes.
Okay, what were the statements that that had an effect on you and caused you to change your steps?
She told me.
Wait,
what her-
no, that's hearsay. I object.
Sustain.
Thank you.
I'll just move.
What did you do next, sir? After speaking with the clerk, what did you do next?
I made contact with the person that the clerk called,
And where was that individual located?
standing next to a vehicle near the gas pumps.
Okay,
See, I could still do this, Ms. Diallo. 31 years later, I could,
How many?
31. Believe it or not. Go ahead.
thank you. Okay, and the individual you made contact, where was he standing exactly?
Next to the vehicle.
Okay, can you describe the vehicle?
It was a red Fusion.
Okay. And was there anybody that was sitting in that vehicle?
No.
Okay, was there anybody else besides that individual standing outside of that vehicle?
No.
Okay, now that individual that was standing right outside of that, was it a Ford Fusion?
Yes.
Standing outside of that Ford Fusion, do you see that individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that individual's wearing?
A black suit coat.
Your Honor, please let the record reflect the witness has identified him.
Record should so reflect.
Thank you. And did you initiate contact with that individual that you just identified when you were at the scene on that day?
Yes.
How did that begin?
I don't remember my exact words, but I think I said, "Hey, what's going on?" Or
Okay.
how's it going?
What happened next?
The radio in the car was very loud, and I believed it was going to be difficult to have a conversation with the person. And I asked to turn the radio down. I said, "Can we turn the radio down?" Something to that effect.
Okay, besides that, was there any other observations that you made?
When I first made contact with him, I noticed
And who's him, just for the record?
the defendant there.
Okay,
When I first made contact, I noticed that the person was unsteady on his feet.
Notice the details stacking up: red eyes, unsteady movements, slurred behavior. To prosecutors, this paints a picture of impairment. But to defense, these are just symptoms anyone could have after a long night or a medical issue.
And he had red eyes, red bloodshot eyes.
okay, and based on your training and experience as a police officer, what is that indicative of, if anything?
I believe that he was under the influence of something.
Okay, and so what happened next?
Against my better judgment, he sat in the car to, I believe, turn down the radio, but that's not what happened.
Okay, what happened next?
The person attempted to put the vehicle in drive and
Oh, okay, before we get to that, where did that individual sit?
dress.
Okay, at that point, was the vehicle on or off?
It was on.
Okay, and after that individual sat in the driver's seat, what happened next?
The person put his foot on the accelerator and tried to put the vehicle into gear.
How do you know that?
So I saw it.
Okay, and what happened next?
I told him to stop twice,
Okay,
very loud,
okay, and why did you tell him to stop?
because I believed he was trying to leave.
Okay, and when you told him stop the first time, did he say anything in response or do anything?
No,
Okay,
he continued to try to put the car in gear.
okay, and what about the second time? What happened after that?
Same thing. He continued his actions,
Okay, and what was his actions that you were observing?
that he was trying to put the vehicle in drive.
Okay, what happened next?
This moment feels cinematic. The officer shouting stop, the defendant still trying to shift into drive. It's more than disobedience, it's escalation, and the jury will remember that tension.
The vehicle got into drive and the driver of the vehicle left.
Okay, and the driver of the vehicle, just, I want to confirm for the record, that's the same individual you identified here in court?
Correct.
Okay, and what happened after that?
The vehicle drove east towards one of the entrances/exits to the gas station onto 4th Street.
Okay, and do you recall what the posted speed limit is on 4th Street?
On 4th Street, it's 50 miles per hour.
Okay, and based off of your observations, what did you do?
My vehicle was parked on the opposite side of the gas station. So I ran back to my vehicle, got my vehicle.
So just so I know, you were on the west side of the building? Is that where you were?
My vehicle was parked on the west side of the building. I walked into the gas station and then I walked out.
So now when you were confronting him, you were on the east side of the building?
Correct.
He pulled out and started traveling southbound on Fort?
No, northbound.
Northbound, okay.
And you indicated that the posted speed limit in that vicinity is 50 miles per hour?
On 4th Street, M85, correct.
Okay, and what did you do next?
I ran back to my patrol vehicle to get in and attempt to pursue.
Did you attempt to pursue him?
I never turned my lights on. I thought I saw the vehicle turning north onto now the northbound lanes. So my assumption was that the vehicle went.
You may object to speculation.
Okay, so you can testify, and I'll keep on record that portion up to my assumption was.
Okay.
All the rest is strict, that language is stricken. You can ask your next question.
I would agree that it is. And so what did you do after that?
I saw a vehicle turning from eastbound West Road to northbound Fort Street. I believed that vehicle was the vehicle that I was after, because I saw taillights of that vehicle turning. So I drove south on the Fort Street to the turnaround to try to catch back up to it, to go back northbound and catch up to that vehicle.
Okay.
There's a no left turn signal there, is there not?
Yes.
So in order to turn from eastbound West Road on the northbound Fort, he had to disregard that signal, correct?
Yes, sir.
And you turned back southbound on Fort, did the Michigan turn, and now we're heading back northbound on Fort.
Yes, sir.
Okay, and were you able to locate that individual, the defendant?
No.
Okay, and so did you learn anything else pursuant to your investigation?
I returned to the gas station and spoke to the clerk.
Okay, and what did you learn?
Oh, no, I would object just to hearsay, anything she said. Thank you.
I learned that
Wait a minute,
What-
slow
hang
down,
on.
slow down.
Judge, I'm not asking for a specific statement, so there's no specific out-of-court statement. I'm just asking also what you learned pursuant to his investigation.
Any response to that?
So I think you can ask, and this is just me, I don't know, it's up to the judge. Based on your investigation, what did you do next without saying the specific words? Because we know hearsay is a statement offered by the declarant, other than while testifying at the trial or hearing, offered to prove the truth of the matter asserted.
Wow.
I've been 30 years too, Judge.
Go ahead,
I would
Mr.
agree.
Muhammad.
Officer, based on your investigation, what else did you discover based on your interaction with the clerk?
I learned that I went the wrong way and was pursuing the wrong vehicle.
Okay, and did you learn the correct way that the individual fled from the scene?
I learned that the vehicle went, I saw the vehicle turn north onto southbound Fort Street, but I learned that it did not go that way. It went west on West Road.
Wouldn't that be hearsay, Judge? What you learned? Because you have to learn it through hearsay. So I would ask that that be stricken objection hearsay. And speculation.
And Judge, I would disagree. I think there's no specific out-of-court statement that's being offered. I think the officer's just testifying to what he learned pursuant to his investigation. There isn't a specific out-of-court.
You have to bring it within an exception, or else argue it isn't hearsay.
Well, I guess my first argument is that it's not even hearsay because there's no statement. But if the court is implying that it is, then
Wait a minute, how's there no statement? If he learned after talking to her, no matter how you phrase it, he learned based on her statement, right?
he learned pursuant to his investigation that the individual had turned a different way. But hearsay is when we're introducing a specific statement. There isn't a specific statement that the officer is testifying to. He's not saying John Doe stated X, Y, and Z. He's just saying, I had a conversation.
It's still based on hearsay, no matter how you cut it. Otherwise, you could get around the hearsay rule every single time. It'd be like anybody asking anybody, what did you learn after speaking with them? That statement is still here.
Here's the heavyweight round. Attorneys clashing not over facts, but the rules of evidence. Hearsay isn't just lawyer jargon. It's the gatekeeper of fairness. And right now, both sides are fighting over what gets through the gate.
Hearsay. I'm going to find that it goes to the declarant's state of mind, and I'm going to allow it.
Understood. Thank you.
Ask your next question.
Thank you. And did you learn based off of your discussion with the clerk, the street that the defendant had fled from? That the defendant had turned onto?
West Road.
Okay, and do you know what the posted speed limit is at that location on West Road?
35 miles per hour.
Okay. No further questions.
Did you ever apprehend the defendant?
Me? No.
Okay. Ask your next, any cross? Do you have cross?
Just 1 second, Judge, I'm thinking, right? real
Okay,
quick.
take your time.
Just one question.
Yes, ma'am.
You weren't sure at first who the person was because it could have been a host of people. Is that fair to say? Like, you said you thought it was the brother.
No,
Well, wait a minute. The brother's name is one of the Belews, right?
are you,
So you didn't know who the person was. Is it fair to say at first?
I did not know that.
I don't have any other questions.
Mr. Mahan,
No further questions.
you can step down, call your next witness.
No further witnesses from the people.
You can step down, I'm sorry.
No problem, Judge.
You have no further witnesses. What are you gonna do?
Judge, I'm gonna motion for a bind over, I believe. Testimony reflects a question of fact to the trier fact, and I'm gonna reserve any remark.
Any argument, Ms.
I
Diallo?
object to any bind over on these particular facts that were presented. We don't have identification. There are a whole host of things that are wrong with this matter. For probable cause, we object.
Mr. Muhammad?
Judge, in regards to identification, the officer indicated that he made contact with the defendant at the scene, and he identified him as being that person here in court today. I think in court identification is sufficient for probable cause. We're not here determining guilt, just whether or not there's probable cause of a crime, and I believe we established that on this record.
Anything else, Ms. Diallo?
No, Judge, you've heard the facts of this particular case. I think I don't know what happened out there, even by probable cause standards, but I believe the officer testifies the person that he thought was doing one thing wasn't doing what he thought. It was the wrong car. It's a mess. It's Judge. We don't think there's probable cause at this stage. So for that, we would ask the court not to bind over.
And Judge, may I have a brief response? In regards to the R&O, the officer indicated that he was in full uniform and that he made contact with the defendant. He gave him 2 lawful commands, at least from what I recall, to stop, and the defendant did not stop. He then fled from that location. The officer he gave the defendant voice. The defendant was a driver of the vehicle, and he gave him voice signals to stop. The officer was in full uniform, and we also learned that the defendant did not stop and willfully fled from this scene. Shortly after, we learned that the posted speed limit on West Road was 35 miles per hour. I know in regards to learning of the 35 miles per hour, it wasn't the officer who had personal knowledge, at least did not appear that way to me. So in the event the court is not inclined to bind it over on the fleeing 3rd degree, I would request it be bound over in 4th degree. Nonetheless, I do believe, because today's probable cause testimony is sufficient as charged, but if the court is inclined not to bind over on the 3rd degree, I would request that it would be done in the 4th degree. Thank you.
Any response to that, Ms. Diallo?
Judge, we still.
I'm talking about with his request to 4th degree.
So, hold on, I'm pulling it up right now, Judge, so I know the 3rd degree should have fallen, with this particular set of circumstances. I'm pulling up 4th degree right now, but we still, how do we get past the, identification therein? You said you went after one car, and then it actually was a different car, so I don't know, Judge, but the 4th degree I'm trying to pull up right now.
So essentially, it's just about the 35 miles.
Yeah, but not only that, Judge, but he didn't even have his lights and sirens on. Remember, he said he didn't. I heard that. Hold on. He said he didn't have his lights and sirens on for number one. But I'm gonna pull it up right now, Judge, to see what 4th degree looks like.
And Judge, just
I've heard enough. I'm troubled here because what you have is an officer that was called, seemingly doing the right things, going over talking to a clerk, deciding he needs to make contact with the subject, goes up, makes contact with the subject, tells the defendant, in this case, Mr. Belaloo, that he shouldn't leave, that he didn't want him to go anywhere. But the very essence of fleeing and eluding is that he's fleeing and eluding the statement. I'm troubled because in this case, you're right, Ms. Diallo, he did not have his lights on. He was not pursuing the vehicle he was not pursuing the suspect vehicle. He didn't know where the suspect vehicle went. For all we know, the suspect vehicle, I shouldn't interject in the record, but there's an area there where you can easily get to a 25-mile-an-hour speed zone. The officer was never in his vehicle chasing him. He thought he went elsewhere. The clerk tells him something to do that as to the fact that the defendant traveled on West Road. We don't know if he traveled on West. The officer thought he traveled on Fort. He observed the vehicle that was...
The judge slams down the gavel and dismisses the fleeing charge. Just like that, the biggest accusation evaporates, reshaping the entire case.
Traveling west or eastbound on West that turned left against a no left turn signal onto northbound Fort. So we honestly don't know where he went, and the officer was not pursuing him in a vehicle. I'm not even going to bind over on flee and elude 4. I'm going to dismiss. I'm going to dismiss flee and elude 3rd. However, I do believe in the face of the questions or the answers that were, hang on.
Sorry.
I'm not going to change my mind.
I understand.
I do believe that there's sufficient evidence, though, to establish that the defendant committed the offense of assault, resist, and obstruct an officer. How successful you'll be in a trial, I don't know, but I'm going to bind the defendant over specifically only on count 2. Count 1 is dismissed. This is interesting. I can't say I've had this one come up, but I do think that there just isn't sufficient evidence to establish he was fleeing and eluding at that time. So I'm gonna dismiss that count. Let me just make a note here, please. So
it's not over. The resisting and obstructing charge survives. The stakes are lower, but the risk is still real. This defendant walks away lighter, yet not free.
Sir, you're bound over to the Wayne County Circuit Court Criminal Justice Center on count 2, assault, resist, and obstruct an officer. Count 1 is dismissed for the reason that there's not sufficient evidence to establish legally if the defendant was fleeing and eluding. So I'm going to bind the defendant over. The bond is continued, $25,000, 10%. It's a surety bond, May 20th, 9 a.m. You don't have any objection to continuation of the bond, do you?
Your Honor, I just have one statement in regards to the fleeing. So the element states being the driver of a motor vehicle.
Given by hand or voice.
Well, yes, was given a visual or audible signal by hand.
I got
voice.
it. I read that. I saw
In
that.
this specific case, it's voice.
Voice, but he didn't flee and elude because the officer never chased him.
So
We don't even know where the defendant went. I hear you, but you're not going to prove that beyond a reasonable doubt anyway. Sorry.
Thank you so much, Judge. It's always a pleasure. I probably won't see you guys for a while.
Yeah, I'm not on the state docket.
No, but thank you.
You take care, Ms. Diallo. Thank you.